Replevin Action was a form of action for the recovery of the specific goods which had either been wrongfully distrained or taken for rent or by way of distress, damage, feasant. It did not lie to recover goods in which the plaintiff alleged merely that he had a right of property or which had been delivered under a contract. It is not available unless the taking of the goods is a trespass. So it is also applicable to the recovery of property taken otherwise than by distress. Although it is very rarely so employed, Replevin almost confined to wrongful distress. So the very maxim is almost opposite to the principle of Replevin Action, and it is almost opposite to distress, damage, feasant. So whenever anybody keeps or detained any animate or inanimate objects causing damage, loss or suffering to his property or land, but when he is not rightfully detained, any such animate or inanimate object which does not commit any suffering, loss or damage to his property, then this maxim Replevin Action would be applicable. So this very maxim would be only applicable to the person who is wrongfully or unlawfully detained or kept any animate or inanimate objects, and for which recovery this very maxim of Replevin Action is applicable. So if it is against the very maxim of distress feasant, then under this very maxim one could get his goods or properties, whether it is animate or inanimate, if it is not committed any wrongful act or any damage or injury is not caused or any suffering is not caused to the person. So this very maxim Replevin Action was a form of action for the remedy of the specific goods which had either been wrongfully distrained or taken for rent or by way of distress, damage, feasant. So this is all about this maxim which is almost opposite to distress, damage, feasant.